Ever think about what happens to a joint bank account if someone ends up filing for bankruptcy? You know, like the kind of account you might have with a parent. Something most of us don't really consider, but it's important.
Right.
We're diving into the complete book on bankruptcy by Peter Francis Geraci, and he highlights some serious risks you probably haven't really thought of.
Yeah, joint accounts can be, well, they can be convenient,
Sure.
but they can also turn into a real legal headache if bankruptcy is involved.
Oh, how so?
Well, you might think, hey, the money wasn't originally mine, so it should be safe.
Right.
But legally speaking, being on a joint account, well, it often means you're considered an owner, even if you never planned to touch those funds.
So even if the money in the joint account really belongs to mom or dad, just having their child on that account could put all those funds at risk if the child ends up having to file for bankruptcy.
Sadly, yeah.
That doesn't seem right.
Unfortunately, it is. Think of it this way. If someone files for bankruptcy, a bankruptcy trustee steps in, right?
Uh-huh.
They oversee things, and they have the power to look at all assets, try to use them to pay off debts.
Okay.
And this could even include money in a joint account, even if it was intended for something specific, like, say, an inheritance.
Wow, that's a real eye-opener. I bet there are tons of people out there who set up these joint accounts without even realizing the potential consequences. So what can you do? Are there, like, alternative ways to manage money and help a parent out without taking on that kind of risk?
Absolutely, there are definitely safer options. One is what's called an authorized signer account.
Okay.
This lets, say, a child help out with things like paying bills or depositing checks, but without actually having any ownership rights to the money.
Okay.
So if bankruptcy happens, the parent's money is protected.
That makes a lot more sense. That sounds much safer. So it's kind of like giving someone a key to help out, but they don't own the house, right?
Exactly. It's about lending a hand without the legal risk of shared ownership. Then there's something called payable on death, payable accounts for short. These accounts automatically transfer the money to a named beneficiary when the account holder passes away.
So it's like a built-in safety net for an inheritance.
Precisely. Bypasses a lot of potential legal complications and ensures the money goes where it was intended. Then there's the option of a power of attorney, or POA.
Now, I've heard of that, but to be honest with you, I'm not sure I fully understand how it works.
Sure. A POA basically allows a child to manage their parents' finances legally,
Okay.
even while the parent is still alive. It gives them decision-making power without actually transferring ownership of any assets.
So with a POA, the parent is still the one in control, but the child can step in and help when needed, all without putting the parent's money in jeopardy, even if the child runs into their own financial troubles down the line.
Exactly. It's a more comprehensive approach, but can be a good option if the parent wants their child to have that level of involvement and control.
Now, what happens if someone already has a joint account and all of a sudden they realize, uh-oh, bankruptcy might be on the horizon? What do you do then?
Right.
What can they do to try and protect those funds, especially if things have already gotten to that point?
Well, the first thing is to try to restructure the account.
Okay.
If it was originally set up just for convenience, talk to the other account holder, the parent in this case,
Okay.
about converting it into one of the safer options we've talked about.
So basically trying to, like, untangle the ownership and make it super clear that the money primarily belongs to the parent?
Yes, exactly. And transparency is key here. Bankruptcy laws require full disclosure of all assets and any changes made to accounts.
Gotcha.
It's not about hiding anything. It's about accurately representing the situation.
Okay, so it's not about being sneaky, just being clear. But even if you do everything right, is there still a chance that a bankruptcy trustee might question these changes, especially if they happen close to the time of filing?
Well, you're right. It's not a foolproof solution. It's relatively rare, but it can happen.
So even with the best intentions, there's still a chance the trustee might raise an eyebrow.
Right. And in some cases, to protect those funds, it might be necessary to file a Chapter 13 repayment plan instead of a Chapter 7.
Hold on, can you break that down for us? What's the difference between those two, and why would a Chapter 13 be a better choice in this kind of situation?
Sure. So Chapter 7 bankruptcy, that's focused on liquidating assets to repay debts as quickly as possible.
Okay.
Chapter 13, on the other hand, that involves setting up a structured repayment plan over a longer period. This plan can actually help protect assets like those disputed funds we've been discussing
Okay.
by showing a commitment to repaying debts.
So it's about, like, having more control over how things go, right? And maybe even safeguarding those funds that didn't actually belong to you.
Precisely. Let's look at a real-life case, shall we?
Okay.
We had a client, Cynthia, who was dealing with some pretty serious credit card debt and needed to file for bankruptcy. But here's the thing. She was also a joint owner on her father's certificate of deposit, which was intended as her inheritance.
Oh, wow. So she was in a really tough spot. She had to file for bankruptcy, but that joint account, that could have put her dad's money at risk, even though it wasn't meant for her to use at that point in time.
Exactly. Classic example of how joint counts can really backfire.
Yikes.
We advised Cynthia to be completely upfront in her bankruptcy petition, disclose the joint account, but we also helped her make it clear that the money belonged to her father.
Okay.
It was intended as an inheritance, not to pay off her debts.
So it's not just about disclosing the account, it's about explaining the context, the intent behind it.
Absolutely. To protect her father even further, we helped her prepare a statement outlining what would happen if the ownership of the funds was disputed.
Okay, so like a backup plan.
Yeah, kinda. She could either fight it in court or switch to a Chapter 13 plan, which would allow her to repay her debts while safeguarding her father's money.
So it's like having a plan B, just in case things get messy. But in the end, was her father's money actually in danger?
Thankfully, no. The bankruptcy trustee didn't challenge the ownership. The intent was crystal clear, and it was obvious that the money was for her father's future, not to cover her debts.
That's a relief. It sounds like being proactive and having a solid legal strategy in place really made all the difference.
It did. Cynthia's story highlights how important financial planning is, especially when it comes to estate planning and dealing with unexpected events like bankruptcy. Understanding all the ins and outs of different account types is absolutely crucial.
Absolutely. So for our listeners out there, what are the key takeaways here? What can they learn from Cynthia's experience?
Well, the biggest takeaway is to be aware of the legal side of joint accounts. They might seem convenient on the surface, but they can create a whole lot of trouble if bankruptcy comes knocking.
It's like the old saying, better safe than sorry, right? Taking the time to get things set up correctly right from the start can prevent a ton of headaches down the road.
Exactly. Think about your long-term goals and consider those safer alternatives we talked about earlier. Authorized signer accounts, POD accounts, and POA arrangements. They offer more protection and flexibility.
It sounds like those options are a good way to achieve similar goals without all the legal headaches of joint ownership. But let's be honest, financial planning can be kind of a daunting task. What advice would you give to someone who feels lost, unsure where to even begin?
It's perfectly normal to feel that way. My advice, find a qualified professional who specializes in these areas. A good attorney can really help you understand your options, assess your needs, and come up with a plan that makes sense for your goals and protects your interests.
So finding an expert you can trust, that's key.
Absolutely. Just like you wouldn't try to represent yourself in a complex legal case, you don't have to go through financial planning alone. Getting professional advice can give you peace of mind and ensure you're on the right track.
Couldn't agree more. Speaking of trusted resources, Geraci Law, founded by the bankruptcy expert Peter Francis Geraci, is a fantastic place to start for anyone facing financial difficulties or just needing some guidance on bankruptcy matters. They offer free consultations and a wealth of information on their website.
That's right, Geraci Law has a stellar reputation for providing compassionate and effective legal representation to individuals and families dealing with financial challenges. Their team of experienced attorneys can help people find the best possible solutions for their unique situations.
So if you're feeling overwhelmed by debt or worried about joint accounts, don't wait. Reach out to Geraci Law for a free consultation. They can provide the clarity and support you need to make informed decisions and take control of your financial future.
Absolutely. And don't forget to check out their informative podcast. It covers a wide range of issues and provides valuable insights from leading experts in the field.
Great resource. So whether you're dealing with immediate financial challenges or just want to be more proactive, remember that knowledge is power, especially when it comes to your money.
For sure.
Educating yourself and getting expert advice can make a world of difference in protecting your assets and reaching financial stability. It's always better to be prepared.
I couldn't agree more. And on that note, it's important to keep in mind that this episode is for informational purposes only.
Right.
Bankruptcy law is complex. Every situation is unique. The information we've covered is general in nature and may not apply to every single situation.
So this is not a substitute for getting personalized legal advice, right?
Exactly. Speaking of which, I want to share the statement from Geraci Law just as it's presented in their materials. This podcast is intended for informational purposes only and should not be construed as legal advice. Attorney advertising. Past results do not guarantee similar outcomes. Listening to this podcast does not create an attorney-client relationship with Geraci Law or any of its attorneys. The information discussed is general in nature and may not apply to your specific legal situation. For personalized advice regarding your financial circumstances or potential bankruptcy options, we encourage you to consult directly with a qualified attorney. Geraci Law provides free consultations to help you make informed decisions. Contact us today to learn more.
And that's a very important reminder. This episode is for informational purposes only and shouldn't be considered as legal advice. Always, always consult with a qualified professional for guidance tailored to your specific situation. Well, folks, that about wraps up our conversation on joint accounts and bankruptcy. We hope you found this episode insightful and helpful.
Thanks for tuning in today. Remember, knowledge is power, especially when it comes to your finances. Having a plan and being prepared can really make all the difference.
Yeah, absolutely. And before we wrap up, let's do a quick recap for everyone listening, just to highlight the key points. First and foremost, we learned that a joint bank account, while it seems pretty straightforward, can actually become a big problem if someone has to file for bankruptcy.
Right, because like we discussed, the law often sees anyone named on a joint account as a co-owner, even if the money in there wasn't initially theirs. And that can have some pretty serious consequences, especially if one of those people on the account ends up having to declare bankruptcy.
Exactly. So it's not just about whose name is on there, it's about the legal implications that come with that. But the good news is there are safer ways to handle things, like those alternatives to joint accounts that we talked about.
Absolutely. Things like authorized signer accounts, those payable on death accounts, the POD accounts, and power of attorney arrangements, all of those give you better protection and more flexibility, and they don't put your family's assets at risk.
And of course, we can't emphasize enough how important it is to get guidance from a qualified attorney, especially if you're dealing with something as complex as bankruptcy or estate planning.
Absolutely. Having a good attorney by your side can make all the difference in navigating those copy waters and making decisions that protect what's important to you.
Well, folks, that brings our discussion about joint accounts and bankruptcy to a close. We hope this episode has been informative and maybe even a little bit eye-opening for some of you.
Thanks for joining us today. Remember, when it comes to your finances, knowledge is power. Stay informed, be proactive, and take those steps to safeguard what you've worked so hard for.
Couldn't have said it better myself. And until next time, happy planning, everyone.